Hello and welcome. This presentation will be discussing the legal rights of domestic violence survivors. And I am the presenter. My name is Bridget Cook and I am the Ellen Bogan Legal Fellow. I'm working with the Legal Assistance of Western New York. And my contact information is on the slides, which provides my phone number and email address. This presentation is meant to give legal information about the legal rights of domestic violence survivors, and it is not legal advice. Please contact an attorney for legal advice. The theme of this presentation is the legal options available to a victim of domestic violence. We will focus on family law legal options during this presentation. However, if you need assistance with other non-family law issues, please reach out if you have any questions. As mentioned, we will focus on family law in this presentation, and we will provide a general overview of these topics: order of protections, child custody, visitation, divorce, and support. October is Domestic Violence Awareness Month. Domestic violence can occur to absolutely anybody. Domestic violence is defined as a pattern of coercive behavior perpetrated by an intimate partner or household member with the purpose of establishing and maintaining power and control. And it is estimated that more than 10 million women and men are physically abused by their intimate partner in the United States each year. Domestic violence includes, but is not limited to, physical abuse, sexual abuse, verbal abuse, emotional abuse, psychological abuse, financial abuse, isolation, minimizing, and blaming, intimidation, coercion, and threats. Now let's talk about some definitions. The parties are called different things depending on what court they are in. In family court, the parties are the petitioner and the respondent. A petitioner is the person who brings the claim. The respondent is the person who the claim is against. There may also be an attorney for the child present in these proceedings. In Supreme Court, the parties are the plaintiff and the defendant. The plaintiff is the person who brought the claim, and the defendant is the person the claim is against. There are multiple courts, and which court you need to be in will depend on what you are seeking. If the matter is a custody, visitation, or support issue, then you will be in family court. In New York, if you are bringing a divorce claim, then you will be in Supreme Court. If you are seeking an order of protection, you may be in either family court or criminal court, or both. Going forward, here are some things to remember about court proceedings. The respondent will be notified, and the respondent can file a response. Also, the respondent has a right to appear in person, and you should be prepared to see the other party in court. However, if it is a situation where you need your address confidential, you can request address confidentiality so the respondent will not have access to your address. As I just mentioned, you can request to keep your address confidential so the respondent will not have access to your address. If the request is granted, then your address will not be printed on any of the court papers. In family court, you can tell the family court clerk that you would like to keep your address confidential. Then, the clerk will give you an address confidentiality affidavit that must be filled in and signed. Also, there is an address confidentiality program for domestic violence victims. It is a free program in New York State, and it is in place for victims who need to move or have moved to a new location because of safety reasons. If you are approved for this program, your address will not be printed on court papers, government records, driver's license, and certain applications. You must apply for this program. More information on how to apply is on the NewYorkCourts.gov website under Court Help and Family Confidentiality. The first real topic we'll get into is an order of protection. An order of protection is a legal document that states that a person is not allowed to do specific things because they have harmed or threatened another person. Orders vary greatly and they depend on the circumstances. For an order of protection, you can file one on behalf of yourself, your minor child or children, or even your pets. An order of protection can be brought in family court or in criminal court or in both. In this presentation, we will focus on the family law order of protection, but please note that there is also a criminal order of protection option. A key difference is that family court orders of protection are only for members of the same family or household. And under New York State, what is considered a member of the same family or household is the following: persons related by blood, adoption, or marriage, or persons who are legally married to one another, or persons who have a child in common, and it does not matter if they were ever married or ever lived together, or persons who are or have been involved in a close romantic or intimate relation. Note, however, that a casual acquaintance or business relationship is not enough for an intimate relation. There are different types of orders of protection, and they can vary a lot. In an order of protection, there will be either refrain from or stay away from, or possibly a mix of both. A refrain from means the respondent must refrain from or stop committing any family offense against the petitioner. A stay away means the respondent must stay away from the petitioner, his or her home, job, children, or any other place the court finds necessary. Additionally, an order of protection can order the respondent to move out of your home, follow custody orders, pay child support, and give up guns. Additionally, an order of protection can be temporary or final. If it is temporary, it will last from court date to court date until the case is over. If it is final, then it will generally last 1 to 2 years, but it can be extended. In the petition, you will describe what the respondent has done. To receive an order of protection, the harm or threats must fall into one of these enumerated crimes. They are as follows: disorderly conduct, harassment in the first and second, aggravated harassment in the second, menacing in the second, menacing in the third, reckless endangerment, assault in the second and third, attempted assault, stalking in the first, second, third, and fourth, criminal mischief, sexual misconduct, forcible touching, sexual abuse in the second and third. The next topic we will discuss is child custody. Also keep in mind that when there are children involved in a divorce case, issues of custody, visitation, and child support must be worked out before the judge will sign the judgment. There are 2 types of custody: physical custody and legal custody. Physical custody refers to who the child lives with on a day-to-day basis, whereas legal custody refers to who makes the decisions for the child. Examples of important decisions are medical decisions, health decisions, and education decisions. There can be sole custody or joint custody. So a court could decide to grant sole physical custody, sole legal custody, or joint physical custody or joint legal custody. However, keep in mind that with joint custody, the court will determine whether the parents can communicate well enough to keep each other informed of the child's needs and to make decisions together. Now let's talk about who can file for custody. The legal parents can file for custody, and I'll get into who are the legal parents. The child's mother is presumed if the child is the mother's biological child and the mother physically had the child. The child's father can be determined a few different ways. One way is that there is a marital presumption, which means that if the mother was married to the father while the child was born, it is presumed that that is the father of the child. The father can also fill out an acknowledgement of paternity form or have an order of filiation. All 3 ways state that this man is the legal father of the child. Now, others who can file for custody are parents who are in a legal parenting agreement. Also, same-sex couples can file for custody, and even other relatives can file for custody. In a normal example, we see our grandparents. Here are some things to keep in mind about child custody. Anyone can file a custody or visitation petition in family court. Also, the parent must name the other parent on the petition, and they must explain the reasons why he or she should have custody. Either parent in a custody or visitation petition has the right to an attorney, and if they cannot afford one, one will be assigned to the parent. An attorney for the child will be assigned to represent the child. The attorney for the child will tell the court what the child wants. There will be court appearances, and at those appearances, the parents will have an opportunity to come to an agreement, but if they cannot, they will go to trial. Also, if a parent or custodian does not appear in court, the court may issue a warrant for his or her arrest, or the court may issue a default order. A court must have authority to hear the child custody case in New York. This can be done if the child is less than 6 months old and has lived in New York his or her entire life, or the child has lived in New York for the past 6 months, or New York issued the last custody order for that child, or the child is in New York after an emergency that occurred in his or her state. When a court is determining child custody, they use the best interests of the child standard. Some of the factors the court will weigh are which parent is the primary caretaker, the quality of each parent's home environment, each parent's ability to provide for the child's emotional and intellectual development, the financial status and ability to provide for the child, any siblings, maintaining stability, compliance of the parents with existing orders, and the ability to co-parent. Also, the court will weigh domestic violence, and a judge must consider whether there has been domestic violence when determining the best interests of the child. As I just mentioned, domestic violence must be weighed as a factor for the best interests of the child. It will be considered for custody and visitation. However, please note that just because it must be considered does not mean the parent who committed the domestic violence will automatically not receive custody or visitation. They may still be granted custody or visitation if the judge thinks the child will not be in danger with that parent and that would be in the best interest of the child. Let's dive a little deeper into visitation. If a parent is not awarded custody, it is very likely they will be granted visitation. New York presumes that it is in the child's best interest to spend time with a non-custodial parent. Courts will create visitation schedules on a case-by-case basis. There are many ways a judge can grant visitation. Visitation can be supervised by an agency, supervised by agreed-upon party, or unsupervised shorter visits, or even unsupervised overnight. It all depends on the circumstances and what is best for the child. Now let's discuss divorce. Divorces can be contested or uncontested. An uncontested divorce means there are no issues in dispute. A contested divorce means there is at least one issue in dispute. As mentioned previously, when there are children involved in a divorce case, issues of custody, visitation, and child support must be worked out before the judge will sign the judgment. Uncontested divorces are divorces where there are no issues in dispute. If you have no children under 21, you can use the DV Uncontested Divorce Program to make your papers. If you do have children under 21, you can use the Uncontested Divorce Packet. Both can be found on the NewYorkCourts.gov website. A contested divorce is a divorce with at least one issue in dispute. If you are filing a contested divorce, you should meet with a lawyer. Also, something to keep in mind is that it is likely both parties will have to go to the Supreme Court many times before the judge can decide on the issues in disagreement. When you file for divorce in Supreme Court, there is a filing fee to obtain the index number. The index number is the number for the case. However, you can apply for a fee waiver if you have financial hardship and cannot file for divorce without financial help. To obtain a divorce in New York, you must meet the residency requirements. If you do not meet these requirements, you may not be able to get a divorce in New York. The following are ways to meet the residency requirement. First, either you or your spouse have been living in New York State continuously for at least 2 years before the divorce case is started. Second, either you or your spouse have been living in New York State continuously for at least 1 year before the divorce is started. and 1, you got married in New York State, or 2, you lived in New York as a married couple, or 3, the grounds for divorce happened in New York State. Or the third way is both you and your spouse are residents of New York State on the day the divorce is started and the grounds for your divorce happened in New York State. Additionally, when obtaining a divorce in New York, you must have a grounds for divorce. There are 7 grounds. The first one is irretrievable breakdown in the relationship for a period of at least 6 months. This is also referred to as a no-fault divorce and is a common ground that is used. To be able to use this ground, the marriage must be over for at least 6 months and all economic issues, including debt, how the marital property will be divided, and custody and support of the children have already been settled. The second ground is cruel and inhuman treatment. To use this ground, the judge will look for specific acts of cruelty that happened in the last 5 years. It is not enough that you and your spouse had arguments or did not get along. The cruelty must rise to the level that the plaintiff is physically and mentally in danger, and it is unsafe or improper for the plaintiff to continue living with the defendant. The third ground for divorce is abandonment. Here, the spouse must have abandoned the plaintiff for at least 1 year. The fourth ground is imprisonment. The spouse must have been in prison for 3 or more years in a row. Also, the spouse must have been put into prison after the marriage began. The fifth ground is adultery. The sixth ground is divorce after a legal separation agreement, and the seventh ground is divorce after a judgment of separation. The next issue we will discuss is child support. Child support is to ensure the child's needs are covered. To determine how much is needed for child support, the court will determine each parent's net income. Then, the court will add the parents' net income together and multiply that number by a percentage, depending on how many children they have. The percentage is 17% for 1 child, 25% for 2 children, 29% for 3 children, 31% for 4 children, and no less than 35% for 5 or more children. The amount is then divided based on the proportion of each parent's net income to the combined net income. In addition to the basic child support obligation, a spouse may also be required to pay for child care expenses, educational expenses, and medical expenses. Let's talk about spousal support very briefly. This is sometimes referred to as alimony. It is a court-ordered provision for a spouse after divorce. The judge will base the income of the moneyed partner to support the other partner in what the court has decided to be fair and equitable. The following are some helpful resources. The DV hotline is 1-800-799-SAFE or 1-800-799-7233. Also, a lot of what we discussed is on the New York Court Forms page. The Law New York website is also a helpful resource. You can also find information at lawhelpnewyork.org, and another resource is www.liftonline.org. If you need legal assistance, please feel free to contact Legal Assistance of Western New York. We have many locations, and you can see the different locations and contact information on our website. The information for the Geneva location, which does involve family law, is provided, and their phone number is 315-781-1465. If you are a resident of Livingston County, New York, and need our legal services, please call 315-781-1465, or you can email lcfamilylawhelp@lawnewyork.org. Also, the Livingston County Family Court is located on 2 Court Street on the 1st floor. In Geneseo, New York, 14454, and their number is 585-371-3919. Thank you for watching. I hope this was helpful.